Hey everybody, this is John Ward, and I'm here to talk to you all on behalf of the Walton County Taxpayer Association. The referendum, which Walton County tried to pass a 1% sales tax, was soundly defeated, 70% to 30% at the ballot. But that is unfortunately not the end of the story. So follow-up work that we've done seems to indicate that Walton County was never even eligible to levy this surtax. And it all kind of came about when the county attorney was asked by Danny Glidewell about new news on the tax. This was at a January 10th, 2023 Walton County Board of County Commissioner meeting, and I'll just play that clip here for you guys.
One other question, Mr. Atkinson, circumstances regarding sales tax has changed, correct?
Correct, based on the statutory changes that are presently in effect and reviewing the matter with DOR, the sales tax that you placed on the ballot during the last general election is no longer a sales tax that Walton County is deemed eligible for.
Just some more good news.
Okay, so it's just about a 20 to 30 second exchange there, but it's incredibly pertinent because, you know, we voted on this in November. This meeting is 2 months later in January, and the county attorney says that there have been statutory changes that take Walton County from being eligible for a transportation system surtax. And now Walton County is not eligible, and something changed. That was interesting because the legislature hasn't been in session. The governor has signed no laws because there's nothing the legislature has put on his desk to sign. So, you know, this begs the question of the county commission and or the county attorney. Well, what precisely changed? Walton County Taxpayer Association board member Bonnie McQuiston at the January 24th meeting followed up by asking those exact questions. When she asked the questions, I want all of you to pay special attention to the body language of the county attorney. He seems uncomfortable that she's bringing this up. And when she doesn't really seem to understand his explanation, he gets flustered. And I think it's going to be really important for us to watch this exchange.
And all that. I really wanted to ask about, I was not here at the meeting when Mr. Atkinson announced that Walton County no longer qualified under the statute for the sales tax referendum. And I'd like to know why we ever qualified. I read the statute, and it's very obvious that we didn't meet the qualifications, but Walton was listed. And I wonder why, if our legal department read it, they didn't immediately ask why Walton was listed. And as they were writing the language, were they aware that we didn't qualify? And then when did they become aware? When did we become aware that Walton did not qualify for that sales tax under the statute as it was written? And why did we go ahead and proceed? If it was prior to the referendum, why did we proceed? A lot of money was spent on that. A lot of time was spent on that if we didn't qualify. And then theoretically, what if that referendum had passed? Would it have been illegal? What would we implemented a sales tax that was illegal? How would that have worked? I just don't understand how this all came about when initially, if you read the statute, we didn't even qualify to start with. So I'd just like to ask those questions. Thank you.
Mr. Atkinson?
The board wishes me to address, I'll be glad
Would
to.
like for you to address.
Certainly. So whenever you move forward with a referendum, Ms. McQuiston, you run all this through the state. And in the handbook published by the Florida Department of Revenue that was in effect all the way through the time the referendum was put to ballot, the DOR's handbook indicated very clearly that Walton County was in fact eligible.
Okay, so Mr. Atkinson is referencing the 2021 Florida Revenue Estimating Conference Tax Handbook. It says that this handbook is what he and the county attorneys use to determine that Walton County was eligible for the Transportation System Surtax. I would like to point out on page 7 that it states all estimates and projections used in this handbook are based on a series of estimating conferences held in July and August of 2021. However, additional conferences will be held in the fall and winter that will revise many of these estimates and projections. And then it gives a number that you can call to receive updates. So they're saying that the document that they are using to justify putting this on the ballot states that it will be updated and that you should check for updates. In the forward here on page 9, I think it's very important to point out here when it's talking about section 3. It says section 3 contains information about major local government revenue sources that are explicitly authorized in the Florida Constitution or the Florida statutes. Says a little bit more and then says, for a more comprehensive description of local government revenue sources, please refer to the local government financial handbook, information handbook, which can be accessed, and it gives you a link to go there. If you click that link and go look at the 2021 local government financial information handbook, which what Mr. Atkinson claims to be the source they used, but if you actually read the source they used and it tells you to go here, you will see that they go over eligibility for the Transportation System Surtax in detail. And that is on page 175. So we'll just mosey on down to page 175. And what we find on page 175, under the Charter County and Regional Transportation Surtax, in this definitive guide, which was published November of 2021, in the second paragraph, it says General Law Amendments, Chapter 2021-188 dissolves the Northwest Florida Transportation Corridor Authority by repealing Part 3 of Chapter 343. Consequently, the non-charter counties of Bay, Escambia, Franklin Gulf, Okaloosa, Santa Rosa, and Walton, which were served by the authority, are no longer eligible to levy this surtax. Although Wakulla County was also served by the authority, it is still eligible to levy the surtax because it's a charter county. This change became effective July 1 of 2021. And I do think the word levy is important because levy means eligible to charge and collect. So clearly, not only after July 1st, 2021, could the county not put this on the ballot to a vote. Well, we can put it to the ballot for a vote, which we'll find out that the county can kind of do what it wants, but it has no statutory authority whatsoever to collect it. And this was effective before we even first put it on the ballot through ordinance back in April of 2022. But let's let Mr. Adkison talk a little bit more to Ms. McQuiston, because it's going to be an interesting exchange now that we know the facts.
And we passed the original ordinance that called for a referendum in April. This is a situation where that goes to DOR. It extended to DOR to even get the OPAGA audit started. DOR took the ordinance, took the resolution setting it. Ms. Thompson's over here nodding because she's the one who made the communications. They approved us moving forward with the referendum.
Okay, so the Department of Revenue is only involved in the county sending them the ordinance so that OPAGA audit, which is required if you can levy it, can be done. The Department of Revenue actually, it's not in their purview to determine whether or not a county is eligible to levy a tax. So Mr. Adkison is sorely mistaken there.
DOR is the one who says whether or not we hold eligibility at the state level.
Again,
their
not
determination was
true.
we were eligible.
He keeps saying DOR. So the Department of Revenue is actually not the department that these handbooks even come from. These handbooks, the tax information handbook and the local government financial information handbook, are produced by the Office of Economic and Demographic Research, which is actually in the legislature that published this. Now, DOR refers people back to this because this is the definitive source of information for them to get. But what Clay is saying is absolutely not accurate, and that is unfortunate for him because he's the county attorney. He should say, I don't know, and I'll get back to you, and not give an answer that obfuscates the question.
Well, at that time, their determination is, and I believe quite clearly, that we are no longer eligible. I concur. We are no longer eligible. We were eligible per state guidelines to put the referendum on the ballot.
Okay. He just again says clearly we were eligible per state guidelines to put it on the ballot. Mr. Adkison, I beg to differ. In November of 2021, the definitive document says that we are no longer eligible to levy this surtax effective July 1, 2021.
It is our position that had the county and its citizens voted for that tax, and it had been levied, we would have been grandfathered in, because you cannot simply.
There is no grandfather provision anywhere in the statute. He is talking out of his rear end right now.
Undo the act of the citizen through legislation.
A judge would not undo the vote of the citizen if the referendum was voted on but was unconstitutional or wasn't even lawful. Actually, we know that to be untrue because this article from the Tampa Bay Times from February 6th is basically talking about a similar referendum which was passed in Hillsborough. This time, Hillsborough actually can levy a transportation system surtax because they are one of the counties that is allowed to do it. And this document says that Hillsborough is allowed to do it. But Hillsborough did not word their referendum correctly. And over a 3-year period, Hillsborough collected $570 million. And Governor DeSantis just told Hillsborough, you are not keeping that money. Your tax was found unconstitutional and by a judge, by the way. And you've got to give the money back. So Hillsborough has this $570 million that they're about to have to give back. Actually, no, Mr. Atkinson, a judge would rule against it if it wasn't constitutional or it wasn't even, authorized for the county to levy the surtax. So you are wrong on another count, Mr. Atkinson.
That being said, at this point in time, Walton County no longer qualifies under the 3 possible qualification methods for the regional transportation system and charter county surtax. So we learned of that when the new DOR handbook came out, that we would not be eligible to seek that tax in the future, barring some statutory change.
Did the eligibility change from originally until when they just told us we didn't qualify?
We were eligible.
Under what eligibility requirement?
Under the statutes, ma'am. And DOR's handbook.
Charter county or what exactly?
We were part of the Regional
what changed?
Transportation Advisory.
What changed with the state between when they said we were eligible and now we're not? Do you know what changed?
Yes, absolutely. The Transportation Advisory interlocal that we were a part of officially expired post repeal of that Transportation Advisory Authority.
Do you know what date?
The date it expired?
Okay. Do you not love how Mr. Atkinson there is just talking in circles? Now, I want you to note that Ms. McQuiston is pushing him on, well, what date was it? What date was it? No, he just said he doesn't know the date. We all know the date because in this, and again, he says DOR, but by the way, DOR does not do the tax handbook. DOR does not do the local government financial information handbook. Both handbooks are published by, and there's a tax handbook, just so I showed you all the other one, is published by the Office of Economic Development and Research. So that they do both of these handbooks, and they are the definitive guides. But again, the change became effective July 1st, 2021. Let's see if he finally will admit that, because he doesn't know the date. That's what he just said. I don't know what date.
I don't know what date the interlocal expired offhand, but I can tell you that the Transportation Advisory Council, the Northwest Florida Corridor Authority, was repealed effective July 1, 2021. That repeal did not in and of itself render us ineligible at that point in time.
That is absolute hogwash. The only criteria Walton County met was the fact that we were part of, by the way, an inactive transportation authority. September 2018 was the last time that the Northwest Florida Transportation Corridor Authority had ever met. And at that meeting, they voted to be inactive, but it wasn't until 2021 that the legislature finally dissolved it. But once it was dissolved, we no longer met criteria, and in the local government financial information handbook, it confirms that. I mean, he is just digging a hole deeper and deeper. I mean, this is bad.
DOR published guidance, and I know Ms. Thompson sent this out several times over, and certainly be glad to send a copy to you of the handbook published after the July 1, 2021 change by DOR. It was published, I believe, in October of that year, published in October after the October and July 2021 effective statutes.
And again, the handbook he is referring to is the tax Florida tax handbook, which again in the note says additional conferences will be held in the fall and winter that will revise many of the estimates and projections. They tell you to check for updates. Even though local governments aren't even supposed to use this, they're supposed to use the one that's made for local governments.
That declared Walton County eligible. We vetted this with DOR. We took it up. We've talked to DOR several times about it. Of course, the position is very simple. We did not pass the tax in the time in which we were eligible. Therefore, we are no longer eligible.
But were we eligible after that July 2020?
Yes, we were.
date?
Yes, the handbook.
Man, I mean, she really held his feet to the fire, and rather than saying, let me get back to you, he just decided to lie. Yes, we were. No, Mr. Adkisson, we were not. Consequently, the non-charter counties of Bay Escambia, Franklin, Gulf, Okaloosa, Santa Rosa, and Walton are no longer eligible to levy the surtax. No, Mr. Adkisson, we were not.
Book published in October of 2021. So July 2021 was the repeal of the authority. The eligibility did not change at that point in time. DOR published notice in October of 2021 saying we were still eligible. We sent an ordinance to them in April of 2022 requesting them to move forward with our determinations. They not only didn't say anything disputing our eligibility, they authorized the state to proceed with an OPAGA audit of the county.
Okay, now Mr. Adkisson's defense of his lack of knowledge and incompetence in this matter is that the Florida Department of Revenue didn't tell them that they weren't eligible. No, the guidance, the local government financial information handbook, which the document that they say told them they could, refers them directly to, says that they're not eligible. But he's trying to use the defense right now that because the Department of Revenue didn't specifically say, hey guys, y'all can't do this, that because they didn't say no to doing an audit on them when requested, that was evidence that it must have been okay because they didn't say no.
We're not going to get to a performance audit if we're ineligible. They wouldn't have ever sent them out to even conduct that performance audit.
Yes, Mr. Adkisson, they sent them and we were ineligible. So you are wrong again. They will send someone out to do an audit if you request it.
So you've got to go through the state when you're imposing a discretionary local sales tax. That's how it works. You don't get just to do it without talking to DOR.
I just didn't understand what changed between the time that we were eligible and then we weren't eligible. I didn't know what changed that made us ineligible.
The change is once that transportation corridor authority that we were an interlocal to was repealed and all interlocal aspects of that expired, that if we had not enacted the tax during our eligibility window, the failure to enact the tax during the eligibility window resulted in our future ineligibility.
Okay. Now he's just like the whole time just making shit up. So eligibility window. Let's refer back to the statute and see where it describes an eligibility window. Let's see here. Eligibility window. Ooh, golly gee, let me read through here. Golly, it doesn't mention anything in here about once your corridor authority is repealed that there's an eligibility window. I I challenge Mr. Atkinson to find a statute that tells you about an eligibility window. And the idea that once a transportation corridor is dissolved, that there's some interlocal agreement that remains in effect and wasn't dissolved. No, it's not. That was it. It's just so wrong that the county attorney has no problems lying to the people.
Note that 212.055, isn't it, Melissa? It received amendments in both October of 2022 and October of 2023.
Wait, we received amendments in October 2023? Mr. Atkinson is a time traveler now. He can get amendments from the future.
It is my understanding that DOR published their manual in November of 2024, in which we are no longer listed as eligible.
Whoa,
I got October 1, 2020.
Can we got to ask Mr. Atkinson who wins the Super Bowl the next few years, because he's now got a new handbook from 2024. Dang.
To change. That's when DOR, upon that change, reevaluated everybody's eligibility. So at the time we passed an ordinance and put the matter to be scheduled a general election, because we can't call a special election for a sales tax anymore. We were eligible to do so. Had the tax passed, we believe we would have been eligible and grandfathered in, and we've received no guidance to the contrary.
Okay, again, we would have been grandfathered in. Okay, just like they grandfathered Hillsborough in, but wait, they didn't. They're actually making them give all the money back after they collected the tax for 3 years. And then the last point, I mean, it's hard to keep all of the disinformation coming from the county attorney straight. It's actually kind of got my head spinning.
Eligible when the ordinance was passed, but ineligible when we had the referendum on the ballot. I understand what you're saying.
You missed it. Okay. We are not.
Wow. Now he's getting upset. No, ma'am. No, you shush. I've had enough of you. You're asking really tough questions, and someone's gonna think I'm lying and or incompetent.
No. We are no longer eligible. Had the referendum passed, it is our position, and we've received no guidance from DOR to the contrary, that we would not be ineligible. We would have been under the eligible portion because the ordinance was passed while eligible.
The ordinance was passed while eligible. So it was passed in April of 2022. And then amended and passed again in August of 2022. And we became unable to levy the surtax due to the dissolving of the Transportation Corridor Authority on July 1st of 2021. I know Mr. Atkinson has demonstrated a difficult time putting dates in order, because he did claim that in October of 2023 and November of 2024, they've gotten some information from Department of Revenue from the future. And maybe if you're getting things from the future, dates can be really hard. But Mr. Atkinson, the ordinance was passed after our eligibility had gone away, and that is clear, absolutely crystal clear.
Vote could not be held till November, no matter what. Had the public passed it, we would have been eligible. Okay. The public didn't, so now there's no future eligibility.
I know. Sorry, one more question. At what point did our legal department become aware that we were no longer going to be, if it didn't pass this time, that we were no longer going to be, that our eligibility had been taken away?
We were aware of that when we first started looking at the funding sources. We knew that as far back as January of 2022, that if this would be our last opportunity to pass.
Wow. So after spending several minutes lying about things, he now says that they knew in January of 2022, indicating to me that they were just hoping no one would be smart enough to figure it out, and that no one would ask tough questions, and that no one would challenge it in court. If this had passed, Walton County would right now be making plans to spend the $40 million a year. We'd be spending money, hiring people, putting time, energy, and resources in, and we could be in the same situation that Hillsborough County is in now, where all of the money taken from the tax would have to be given back. And what a mess we would be in. And it's all because we have a county attorney that is just flying by the seat of his pants and really, really shouldn't be there. Very disappointing. I just want everyone out there to watch this and think about, at this point, how do you listen to anything else, any more legal advice that he has to give? It would have been great if he had just fessed up initially, and when Ms. McQuiston asked her questions and said, you know what, Ms. McQuiston, we messed up. We thought we did, we didn't. I mean, it'd be embarrassing. But now, I mean, it's clear that he's lying.
This tax for an extended period of time.
Thank you.
So I put this out there for all of y'all to look at, for you to evaluate for yourselves. You know this county's in trouble. We have the worst leadership of the county commission. I mean, as someone who grew up, born and raised in Walton County, it breaks my heart to see the county government run so poorly. And then to see a county attorney who just either doesn't understand or knowingly misleads everyone on an issue so important like this. So please take the time to share this information with other voters, because all we can do is clean house in 2024. I hope y'all agree with me. I don't want to see a single one of the three who are up for re-election back up at that podium. And then, we need professional legal advice. I would recommend a change there as well, because we're just not getting what we need, and we need to move forward and get with the 21st century here. Y'all have a great one. Okay.